Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute legal, financial, tax, or psychological professional advice. The legal landscape regarding family law and domestic relations varies significantly by state and jurisdiction within the United States. Viewers should not act upon this information without seeking professional counsel from a licensed attorney, certified financial planner, or qualified professional in their specific area. The use of this content does not create an attorney-client relationship. All case studies and historical trends mentioned are for illustrative purposes and do not represent a certainty of results. You are encouraged to conduct your own due diligence and consult with experts before making any significant life decisions. The American divorce system is a $40 billion a year engine fueled by a fundamental lack of procedural literacy. Statistics from historical trends over the last decade suggest that the average contested divorce in the United States now costs upwards of $15,000 per individual, with high-conflict cases easily spiraling into the six-figure range. But the true cost is not just found in the retainer fees of a law firm. It is found in the years of lost compound interest, the degradation of parental relationships, and the psychological toll of navigating a system that was historically designed to be adversarial rather than restorative. We are currently witnessing a shift in the American legal landscape. In 2026, the rise of the pro se litigant, the individual who represents themselves, has moved from a fringe occurrence to a mainstream necessity. However, representing oneself without a comprehensive education is like attempting to perform surgery on oneself because one cannot afford a doctor. It is high stakes, high risk, and often results in long-term damage. This is why we are initiating an academic discourse on the concept of compiling a divorce university online. This is not about a quick fix or a shortcut. It is about treating one of the most complex legal and financial transitions of your life with the same intellectual rigor you would apply to a master's degree or a doctoral thesis. The concept of a divorce university is an organized, modular, and data-driven approach to personal crisis management. Instead of reacting to motions and subpoenas with fear, the educated individual compiles a curated curriculum of legal frameworks, financial forensics, and jurisdictional precedents. Most people enter the divorce process as victims of circumstances. We are discussing how to enter it as a scholar of the process. This masterclass is designed to solve the problem of information asymmetry. In the legal world, information is the primary currency. When one party understands the nuances of equitable distribution versus community property, the tax implications of liquidating a 401k versus an IRA, and the historical trends of custody evaluations in their specific county, the power dynamic shifts. This series is your syllabus. We are going to deconstruct the American divorce process into its core academic components, providing you with the framework to compile your own personal database of knowledge. We will explore the architecture of the U.S. court system, the mathematics of asset division, and the psychological profiling required for high-conflict negotiations. By the end of this deep dive, you will understand how to transform a chaotic life event into a structured project that prioritizes the preservation of your future assets and the stability of your family unit. To understand why this academic approach is necessary, we must first look at the historical trends of family law in the United States. For much of the 20th century, divorce was a fault-based system, requiring proof of adultery, cruelty, or abandonment. The shift toward no-fault divorce, which began in California in 1969 and eventually spread to all 50 states, was intended to reduce conflict. However, historical data suggests that while it made the exit easier, it made the division of the spoils infinitely more complex. In 2026, we are dealing with digital assets, cryptocurrency, remote work jurisdictional issues, and complex pension valuations that the original drafters of no-fault legislation never envisioned. This complexity is why the traditional model of simply handing a folder of papers to an attorney and hoping for the best is increasingly ineffective for the modern American. Case studies of high-net-worth separations over the last 5 years indicate a clear pattern. The individual who treats their divorce as a full-time research project consistently achieves more equitable potential outcomes than the individual who remains passive. For example, consider the historical trend of discovery in the digital age. Discovery is the legal process of exchanging information. In a traditional setting, this involved boxes of paper. Today, it involves forensic analysis of cloud storage, social media metadata, and encrypted communication logs. Compiling a divorce university online means learning how to manage this data. It means understanding the rules of civil procedure that govern how evidence is admitted in your specific state. If you do not know what a subpoena duces tecum is, or how to properly format a request for production of documents, you are already at a disadvantage. This masterclass will dive deep into the 4 pillars of your self-compiled curriculum.